Court does call the case, People versus Rebecca Valentine.
That's Lonnie for the people. Assistant Public Defender Chinaze Carey. I can really on behalf of Rebecca Valentine, Your Honor.
Valentine, can you state your name, please?
Yes, and I did say I want to represent myself, so I don't know where that communication was spilled. Rebecca Valentine, I don't wish to have an attorney represent me.
Okay, you want to represent yourself in this matter?
Yes,
Okay, so what do you want to do today if that were the case?
what are my options?
Pardon?
What are my options?
I can't apprise you of that, ma'am. I can't give you legal advice.
Probably just adjourn it for 2 weeks and they can let me know what they want to do next.
Have you spoken to the public defender or an attorney at all, ma'am?
Yes, she was very inconvenient, not communicated with me, and I let her know I would like to represent myself. I think that you're allowed to tell me like reasonable information, and then I can make a reasonable choice about my own representation. Is that not my right?
Well, thank you for letting me know what my job is, but that's not how it works.
You're welcome, but I would think you should know this already.
October 24th, 2024, 9 a.m.
Sounds good.
I'll consider that a waiver of her time requirements. Bond continue. Thank you.
You're welcome.
Should I put anything on the record?
What'd you say?
I guess it would be fair. For the record, Your Honor, I did try and reach out to Ms. Valentine.
How'd that go?
It didn't go very well, Your Honor.
Oh, I'm just asking. I don't know. You don't have to answer me. That would be privileged. Did it go as well as my conversation just now?
You actually heard her voice. So
Oh, okay. That must be part of my charm.
Good morning, Rob J. Kilwell, Judge. I'm standing in for Sam Bernstein, who is attending his grandmother's funeral. I've had a chance to speak with
Sir,
him.
do you have any objection to that?
Yes. You have objection to me standing in for Sam just for this hearing?
Yes. You do?
Your Honor, we just spoke. All I'm going to do is ask for an adjournment. You want Sam here to ask for that?
No.
Can I ask? The judge is asking, do you have a problem with me standing in just for today, asking for the adjournment?
You can ask for the adjournment.
Okay, but that's not the question. Do you object to me handling your affair just today?
Yes.
You
Okay. Let's do it this way. Because I'm not going to go through this one.
Okay, all I was going to do is ask for an adjournment, then Sam will be back next time. Okay, but you have to tell the judge it's okay for me handling your affairs just today.
Okay.
Tell the judge that
It's okay.
I handle your affair today.
Yes.
Okay.
Judge, thank you. That being said, my instructions were to ask for a 2-week adjournment, please.
No objection, Your Honor.
Probable cause conference, October 24th, 2024.
Yep. Okay. Go! Will you hand me my screen box? Now go. Freak! Rah!
Court calls case People versus Wayne Eggleston or Eggleston.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Eggleston.
Your name, sir?
Wayne Eggleston.
All right. I have before me a plea form that indicates the defendant is going to be pleading guilty to the charge of attempted unlawful use of a motor vehicle, 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. I guess that's SA is sentence agreement.
That's correct, Your Honor.
Sentence agreement to 1 year in jail, which this court could not bind the sentencing judge to, although I understand it's your agreement, and no delayed or deferred. Again, this court is not binding the sentencing judge to that.
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Wayne Eggleston.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted unlawful use of a motor vehicle.
Correct.
All right, that's a misdemeanor punishable by up to 1 year incarceration and a $750 fine plus court costs, as well as license suspensions by the Secretary of State. You understand that?
Yes.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
Correct.
All right. Still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct, sir?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
All right. Which one?
Probation.
All right. Were you on probation at the time of this offense?
No.
You sure? You don't know.
It's the same offense in a different county. Same day, same offense. Different charge.
All right. So you're on probation in another county
For this.
that happened after or for this, but the events occurred in a different county.
Yep.
Okay. Then I don't think you need to.
Another different charge, different county, same case.
Same possession of the same vehicle in a different county.
Yep. Same vehicle, same accident. Yep. Different county.
All right.
Add another charge to it. Yep.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced?
No.
You're doing this voluntarily
Correct.
of your own free will
Yes.
because you believe that you are indeed guilty?
Yes.
July 23rd, 2023, at the location of 9575 Austin Road, Bridgewater Township, Washington County, State of Michigan. What'd you do that makes you think that you're guilty?
I used one of the work trucks and got in an accident.
Did you have permission to take that truck? For that purpose?
Not to get in an accident, no.
Well, did you have permission to take the truck at all?
Depending on the circumstance, but no, let's say no. Let's go with no.
You had permission to take the truck for work purposes, correct?
Yes.
And you took the truck for non-work purposes?
Correct. There
And
you
you
go.
didn't have permission, is that correct?
Correct.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, sir.
Whoa, not the.
Oh, he thinks it's funny that I'm, it's,
I don't think anything's funny about it, sir. I'm just telling you, you weren't answering my question.
I used the truck for non-work purposes, so I didn't have permission at the time that I took it. Correct.
I'm sad. Defense is satisfied. Thank you, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
October 29th at 9 a.m. before Judge Freshour.
October 29th, 2024, 9 a.m. before Judge Freshour. Bond will continue. Thank you.
Thank you,
Thank
Your
you,
Honor.
Court calls the case. People versus Akeem Burks.
Your Honor, Mike Gaddy, Assistant Public Defender on behalf of Mr. Burks, who is supposed to be here by Zoom. He is not.
Is my smiling? Is my smiling at you making you? Is this seem funny?
Assistant Public Defender Jay Bellinger on behalf of Robin Finney, whom I don't believe is here, Your Honor. I've made every attempt to call her, left her voicemail, text message, email, sent carrier pigeon, no response. I am also aware of the failure to appear community corrections alleged violation. So I haven't heard from her. I could request adjournment if you would grant one. That'd be great, but I understand you're probably not going to do that.
Bench warrant.
Okay.
25,000 cash surety. That warrant will issue immediately.
Hey, if we don't ask, we're never going to get it right.
That's right. Court calls the case. People versus Brian Haggard.
Mike Gaddy, Assistant Public Defender on behalf of Mr. Haggard, who's approaching as well, Judge.
Your name, sir?
Brian Haggard, Your Honor.
Thank you.
Your office right now.
All right.
two positive tests for cocaine. And it is a case that I am requesting an adjournment. It came in as an OWI investigation. I wanted to charge it immediately, given this person's substantial substance abuse and the violence given to the police officer, given that it's an RNO case. Since then, his blood has come back, and I am ready to move forward with an OWI third charge against him. But I'll need to authorize that and then have it resworn to, and then if we could address the bond violation as well. I'm sending this in, but summarize September 5th, benzodiazepine and THC and buprenorphine positive, November 11th missed, November 12th, those same three substances as well as cocaine, despite not earlier. November 20th positive for those two substances as well as cocaine.
November.
Yeah, I'm not reckoning we got there yet.
I'm sorry, I'm needing to say September. I'm so
Thank you.
sorry. September 5th, September 11th, September 12th. I apologize.
Got it. It's okay.
September 20th, buprenorphine, cocaine, THC. September 24th, missed. September 28th, buprenorphine, THC. October 3rd, buprenorphine, THC. Sorry for that.
All right.
It's in my car.
12, cocaine positive is confirmed by Redwood toxicology. And that is.
Okay. You said cocaine was confirmed?
Yes.
Your Honor, while we don't have, since there's another case coming, we don't, it doesn't make sense to hold the exam on the RNO, than to set the other one. So I wouldn't object to the adjournment. Actually, I filled out the green form, so I guess I don't. In terms of the bond violation, Your Honor, I believe there's been some tests as of late. He does, Mr. Hager does have a prescription for the buprenorphine, the Suboxone that we can provide to. They should have.
Okay, so what about the cocaine?
Your Honor, he denies that. We've certainly he sent that out to the Redwood. Had community corrections send that out to the Redwood lab for verification. I believe it did come back. I believe there has been tests since then. These tests were in September. We're now almost in double digits in October. I'd ask the court to adjourn this matter and keep the bond violation pending to allow him to demonstrate to the court that he can comply with the court's testing, not just its directives, but its mandates that he not test positive for these substances.
This time, I'm going to adjourn this out. I'm only going to adjourn it out 2 weeks. He's going to have some other type of plan in effect or some other type of thing. But at this time, I'm going to revoke the defendant's bond. Defendant's remanded to the Washtenaw County District. Court does call the case of People versus Eric Harris.
Was here. Yeah, this is a public defender on behalf of Mr. Harris, Your Honor.
I need to be back.
Hey, Sharon.
My name is Eric Jones. Eric Harris.
All right, what are we doing now?
Your Honor, we have two matters up. I have prepared and signed a request for screening into the 15th District Mental Health Court. Actually, I need to absolutely.
And how long is that taking, you think?
Your Honor, they meet every other Wednesday, so maybe 3 to 4 weeks.
3 weeks.
They just met, yes. Well, I attended, it was yesterday.
Probable cause conference, October 31st, 2024, 9 a.m.
Your Honor, support received progress report from community corrections that indicates the defendant was testing at Ann Arbor Treatment Center has had positives at that facility. I think the report was dated October.
I have that. He actually has a bond out. He actually has a warrant out at this point.
Yes, Your Honor, if I may address that.
Go ahead.
Your Honor, Mr. Harris, there was the testing information. He came to my office on Monday morning. We discussed the matter with or Tuesday morning, I can't remember now. We discussed the matter with his provider at the treatment center. he informed us that Mr. Harris is prescribed methadone and it's provided for him there. He also said that he had provided a new test to Community Corrections that was dated October 9th, I believe that, or October 7th, that was clean for things that he was not prescribed for. And I reached out to the agent and to see if he had the tests, and he hadn't. I believe Mr. Harris would, if the court wanted to test him today, would likely come back negative. I'd ask the court to consider.
He'd come back negative today?
Yes, except for, I think for the, what is it called?
Methadone.
Methadone, sorry, Judge. But, in talking to his agent there, I guess, in certain circumstances, fentanyl can stay in your system for some time. But I believe he's had a negative test recently for fentanyl that his agent advised that he had sent over to Community Corrections. This
Did
is
you
a
see the screening results?
may approach and make sure I have the right ones. Yes, Judge, I have seen those, and I believe there's an October a more recent test than that is negative.
And Your Honor, I do believe that people have received the same documentation. This is not a format that I am personally accustomed to receive drug results in. However, it is my understanding that it indicates the positive urinalysis on the 9th, November 10th, November 18th, November 26th, each for methamphetamine. There also could be positive tests from
Yeah.
the methadone is a separate test, which is under here as MTAB versus
Yeah.
MTAB, I believe. I believe MTAB indicates methamphetamine. My best understanding, it may or may not, but the MTAB is what I believe indicates methadone. I believe that's different.
It is.
result. And then I also see, if I'm reading this correctly, positive fentanyl tests from 8/28, 9/9, 9/10, and negative on 9/18. It's interesting, and then positive on 9/18.
Your Honor, if I might, I believe the meth portion is methadone, the MTAB, and speaking to Kenneth Hammond from the treatment facility, the meth is methadone and the MTAB is a metabolite, and the fentanyl is, well, fentanyl. That's my
Okay.
understanding from speaking to him.
But why is fentanyl showing up?
Your Honor, that Mr. Harris Jones is currently on tether. He is working to maintain sobriety. I believe his latest test, where we did, and Mr. Hammond said he sent it over to Community Corrections. I can call and see. I had hoped the court would have it. Was negative. He reported that to me earlier.
Right, but all that's gonna tell me is that he's periodically using. Because the one before that on the 18th is negative regarding fentanyl, but then the 26th is positive.
Can I speak, Your Honor?
If you want to.
Yeah, never mind.
Let me tell you something, folks. You can't fix stupid.
Yeah, I'm not using periodically though.
Pardon?
I'm not using periodically. That was just never mind. Go ahead. Never mind.
Your Honor, as I said, he is in a program. He is, I believe he is endeavoring to work his hardest at it. His latest test would be negative. I'd ask the court to consider admonishing him not to use to continue testing and to stay within the parameters of the treatment program that he's involved in currently. He has several things going for him. He does have a meeting next Tuesday on the 15th at 3:00 with Community Mental Health. He's been going through their screening process. This is with the housing people.
Okay. I don't have a problem with any of that. But what I'm going to do at this time, I'm going to remand the defendant $25,000 cash surety bond on each case, which was the bench warrants that I set. And then once he is looked at by the folks at I will reconsider that. I don't have a problem doing that, but there doesn't seem to be much of this that's kind of holding him in at this point, and that's what concerns me.
Thank you, Your Honor.
I'll set it for the 31st at 9 a.m.
Thank you.
Court calls the case of the people versus Musa. Thiem.
And good afternoon, Your Honor. Sydney Rushing, appearing on behalf of Mr. Thiem. Mr. Thiem, can you please state your name for the record?
Musa Thiem.
Thank you.
All right. What are we doing?
Your Honor, we submitted a request for an adjournment. We just need a 2-week adjournment on this one for resolution.
There is a bond violation. Are you aware of that, counsel?
Yes, I did receive that from the court yesterday, Your Honor.
All right. Well, he hasn't tested.
Your Honor, I did discuss that with Mr. Thiem. He woke up late and then did not have a ride to the testing center. I did have a discussion with him and explain how important it is that he needs to appear for testing no matter what, no excuses. And I explained to him what Your Honor can do if he does not get in compliance. He understands that. And Your Honor, I think that hopefully this is not an issue anymore.
Thank you, Your Honor. This was similarly an issue when we were here on September 26th. We adjourned for him to meet. That's my notes for him to get as well. The fact that he still hasn't gone is concerning.
Right.
Your Honor, he did enroll. He enrolled on the 26th of September. He left court and went directly over to community corrections. He just missed the test on October 3rd, or at least that's my understanding.
Yeah.
Well, but he was testing on the 27th. He didn't test on the 27th.
I see that, Judge. I apologize. In my eyes, I read that as the 26th. I thought that was the same date that it went in. So that's my apologies, Your Honor.
Right. So he was to test on the 27th, unable to refuse. October 3rd, he just missed.
Right. Yep.
And that was after, hold on, that was after I reissued the testing order to it.
Yes, Your Honor.
So why should I be giving him another break?
Your Honor, I think with Mr. Thiem, his age and being young and just now going through this type of situation, I just want to let Your Honor.
Front of me. He was right in front of me and I told him what he needed to do and he hasn't done it.
Correct. Your Honor, yes, I see that he has missed that test on the 27th as well as the 3rd. He did leave the court and go at least check in there. You know, he left right directly from the courthouse and walked over to community corrections, Your Honor. But again, I've given him a very stern talking to about how important it is that he be in compliance with Your Honor's orders. And I think he understands that at this point. So I'm just asking Your Honor to just give him one more opportunity to be in compliance. I hope he does, but I think he's going to.
No, that's not how this works. I mean, I issued a new order, gave him a break the first time when he didn't even go over there. He ignored the magistrate's orders and then he just ignored mine.
I understand, Judge, completely.
I will adjourn this out 2 weeks to the 24th. Well, no, I'm not going to do it that way. It's adjourned out to next week, the 17th. Defendant's bond's revoked. He needs to turn himself into the Washtenaw County Jail by 6 p.m. today.
Got it, Your Honor. I'll let him know.
If he doesn't turn himself in by 6 p.m. today, I'm going to issue a warrant with no bond.
Thank you, Judge.
Thank you. Court calls case people versus Philip Zabawa.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Zabawa. Can you state your name for the record, sir?
Yes.
Can you state your name, please?
Philip Zabawa.
Your Honor, we'd be asking to set the matter for preliminary examination.
All discovery is complete.
To my knowledge, it is.
People would have their witnesses available the 22nd.
Just one moment, please, Your Honor.
Mm.
Your Honor, is the court received the violation?
I am.
Sorry, would the court mind if we could address that first before we set the exam date? We could potentially do the 22nd, but I'm extremely concerned. As recently as October 3rd, was testing positive for fentanyl and opiates.
Go ahead, man.
It's my understanding that those positive tests did exist. My client has provided with us a letter from Sacred Heart. He gets scheduled for intake there at October 14th. So while it looks like he may have had a relapse, he is taking the appropriate measures for his recovery.
Yeah, may I make a statement?
You may.
I don't want you to unless you tell me what you're going to say first.
I just take something.
Mr. Allen.
And Your Honor, the concern of the people is, of course, the most recent positive test being a week ago today, but also that the defendant has never tested negative. Every single test he's supposed to submit to community correction has either been missed or positive.
I'll just take it.
As my client reports, it was not his intent to be taking fentanyl. He didn't know that was in the substance that he had used. He does understand that he has
What was he intending on using?
pills, Your Honor. I don't want you to say it because if you say it, it's an admission. If I say it, it's not.
Well, I didn't know about all that. Anyway, anything else?
Judge, only, like I said, he has the intake scheduled for the 14th, so he is taking the appropriate steps to manage that. I would ask the court to allow him to go to treatment and stay out of custody.
Still want it set for exam?
I do, Your Honor. And he does indicate to me that Bright Recovery would take him today. He just doesn't, but he has, I don't have any paperwork to that effect, but that's just what he's reporting. They wouldn't, okay. That's
Your Honor, unfortunately, I'm sure the court has this on the community corrections report on the second page indicating that the defendant said that he had a tree fall on him. He wanted to get into inpatient on 10-2. It's sort of like lots of information provided community corrections about plans. And now there's another plan for the 14th. And I understand that is his hope. But the concern of the people is whether or not he's going to make it to the 14th, frankly.
Preliminary examination will be set the 22nd, 2024 at 9 a.m. That is before Judge Fresh Hour. This time defendant's bond because of the positive test and community corrections violation. His bond is hereby ordered revoked. Defendant demanding.
Somebody will see you, sir.
Court does call the case of the people versus Jorge Terraza Asensio.
Good morning, Your Honor. Marie Tanhall, Assistant Prosecuting Attorney.
Assistant Public Defender Jay Bellinger on behalf of Jorge Terraza Asensio. And Your Honor, we are just asking for a 3 to 4 week adjournment for an immigration consequences analysis. I submitted the request to my office yesterday, so I'm trying to expedite that as soon as possible.
Your Honor, before I respond to that, I'd like to address bond.
Go ahead.
Thank you. Well, I don't see a criminal history that we're aware of, and I'm not aware of any violations at this point. I am very concerned that this defendant was given a PR bond, given the nature of the offense and what happened. The defendant dragged his 16-year-old daughter off the bed and continued to punch and slap her in the face and the stomach in the name of discipline simply for being on the phone. Only days before this happened, he had assaulted and strangled her mother to the point where the mother could not breathe, had trouble speaking afterwards, and this was all witnessed by this child and other children involved. Our office requested a $15,000 surety bond. This is a case I would have a lot of concerns about given the strangulation and then days later the abuse of the 16-year-old child.
Response.
Your Honor, my client does have and does maintain his defense of self-defense at this time.
Defensive self-defense?
Correct. With regard to bond, my client faces potentially severe immigration consequences. I'd ask that the bond remain the same, Your Honor, as we look into those immigration consequences in the analysis. And I would remind the court what the prosecutor stated, and that my client has had no allegations of either contact with any of the alleged individual witnesses involved, nor has there been any allegation that he's gone to the place where he cannot go, the address. And I am very concerned, considering that he's been here for at least the last 15 years, that if he goes into custody, he may trigger immigration. And I would provide, Your Honor, that he does work and he provides for his family and needs to continue to do that in order to at least financially support that family. He does also have support from the community. He does have a friend whom I spoke with yesterday by the name of Mario Lopez, who has been assisting him and who has also been assisting me in making sure that he has all the correct information and knows not to violate bond, etc. Thank you.
Gracias.
Did you indicate that the choking incident was the mother of the child or the child herself?
The mother of the child.
And when did that occur? Reference this event.
And I believe it was days prior. About 10 days before this incident.
Because what I have is that 10 days prior to the event, that he did that to the daughter, had two hands on her throat where she struggled to breathe.
I apologize, Your Honor, you're correct.
Okay. Bellinger, I have some concerns about what you said. I get that there may be a self-defense. I will just indicate that the magistrate notes indicate that the defendant admitted to the argument because the daughter was suspended.
That is, Your Honor, if I may respond.
Go ahead, Madam Interpreter.
I do want to add that in my analysis of the police report, that there are potential additional defenses of parental discipline that we are investigating. There is an allegation too, Your Honor, that the child did put her hands on my client, which is what I spoke to at the first half of the argument. Thank you.
Court listening to the argument would find that the magistrate setting of the personal recognizance bond, given the circumstances, court would find that that is an abuse of discretion based upon the facts that have been given to this court. The court will set the defendant's bond $15,000 cash surety. I will adjourn this matter to the November 7th, 2024, 9 a.m. to allow an immigration consultation to take place. All right, defendant remanded. Court calls case People versus John Lee McHugh.
Attorney for the people sending in for purposes of
Good afternoon, Judge Larry H. Margolis. On behalf of the defendant, Mr. McHugh, who is present. John, please state your name for the court.
John McHugh.
Judge, today's the date and time. We adjourned once on this matter. I was able to review the forensic interview, which led me to realize there was some other items for discovery that I was seeking. Out of an abundance of caution, I filed a motion. We are not seeking to be heard on the motion for discovery today. There's really only two items, and I brought it. I will bring it to Ms. Tana's attention, those items. I would ask for one short adjournment, a couple weeks, if possible, that we can get the discovery issues resolved and then have it set for an exam. Or if Your Honor would prefer it to be set for an exam, we can do that too. Because I'm almost done with everything that I need, but there are some records that are outstanding.
Ms. Tana?
Thank you, Your Honor. If I may unpack all of that. So the motion, of course, we don't wait 7 days, so it sounds like it's not being heard today anyway. I'm not sure why a motion was necessary, but if Mr. Margolis just contacts our office, And perhaps currently contact me because Ms. Rice, I guess, isn't speaking to him anymore. We'll make sure that he gets at the appropriate time.
I'd be
Yeah.
glad to contact.
I didn't understand the motion either.
You're right.
Need to step up.
I know he has a,
Why don't I?
this is a surprise to me, Your Honor. It's not happened before.
It's happening. It's happening. It happened. What are you doing? Well, you're really doing it, aren't you? You're just shitting in the street. Away! Oh!
You want to take him something? Yeah, he can take the waste basket. You can take that with him too. Yeah, take that with you.
What did we eat?
I'll buy a new one.
Nope. Yeah, you might want to get out of the way there, Constantino.
Oh. It's coming out of me like lava!
We'll buy a new one. Has to buy Alan a drink.
Don't worry. Nobody has to clean that up. We got people. All right.
Your Honor, that was not because of me.
Oh, yeah. It absolutely was. It would have been no one else if that would have happened to.
Really walked in at the wrong time. Really walked into it.
I don't know. Did I even call?
Yeah.
Court calls the case, people versus Aaron C. Good. Court recalls the case, people versus John McHugh.
Thank you, Judge. Back on the record, Larry Margolis, Lawrence Margolis, on behalf of Mr. McHugh, we apologize. I've been advised that Mr. McHugh took some anxiety, non-narcotic, anti-anxiety medication this morning, prescribed. He hasn't taken it in a while, and it had a bad effect. He had already talked to his work that he wasn't feeling well. So that was the reason. He's fine now, correct, John?
Yeah. Apologize for that, Your Honor. Sorry.
Okay.
I didn't want to throw up on the floor, man. That's why I was like.
All right. Where were we? My understanding is that there's going to be some discovery that is provided to you. You're going to talk to the prosecutor. Everybody else does. I'm not going to hear the motion, and that's all going to get resolved. Probable cause conference, November 7th, 2024, 9 a.m. Fun. We'll continue.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
Always a pleasure.
Yes, sir. Court calls the case, people versus Nakiva Wiley. Nakiva Wiley, counsel, state your appearance.
Good afternoon, Your Honor. Tina Saxon for Nakiva Wiley.
Nakiva Wiley.
Okay, you're not driving, are you?
No, sir.
All right. Okay, what are we doing, Ms. Saxon?
Your Honor, at the appropriate time, I'd like to make a bond argument, but for now, I ask for a date for a preliminary exam.
All right. So I'll set the preliminary examination in person for the October 22nd, 2024, 9 a.m. before Judge Washington. Bond in, well, go ahead. You said you had an issue regarding bond.
Yes, Your Honor, Ms. Wiley is on a tether, and I'm asking that, given her record is, to my knowledge, non-existent, that she be relieved of that tether. And in addition, I tried to verify this, but I received word that the alleged victim in this case, Jada Escamilla, has vacated the apartment, no longer is staying there. So I would ask for the no contact to be lifted for that location because Ms. Wiley's trying to terminate the lease on that apartment, but she's not allowed to go there to deal with the matter.
I would object to both. So she is the mother of Marcus Williams. The victim resides in the apartment with Roman Williams, which is a domestic violence case that was up earlier today, I believe. She goes to the apartment knowing that the victim is in the apartment and tries to physically remove her and physically evict her from the apartment, which is what led to these charges. I do not believe that an eviction process has even begun against this victim. I charged this case, and at the time of charging and appearing at the arraignment, this was the victim's address and this is where she lived. And because she had already paid rent to her boyfriend for that month, she did not have, for September, she did not have money to go anywhere else. So I'm objecting to the tether being removed because the victim, we need that tether to protect this victim. This woman went to this apartment specifically with the intent to physically remove her from the apartment. And then the last information I have is that the victim resides in this apartment and that is her home.
Ms. Saxon, well, first of all, regarding the tether, I'm going to deny that request. I'm not removing the tether on this case. Are you saying that eviction proceedings have begun on that unit?
According to Evergreen, because Ms. Escamilla was never on the lease, she can't be evicted by Evergreen Apartments or McKinley Properties because she was not a tenant. Ms. Wiley was paying the rent. There's only two supposed receipts of Ms. Escamilla paying rent. One via Cash App that says for rent, and that would have gone to Roman probably. The other one doesn't say it was for rent. It's just her word saying it was for rent. Ms. Wiley, however, has a plethora of proof that she pays the rent on that apartment for her son.
But the victim's there.
And again, the word I received was that the victim has left. I'm sorry.
Pardon?
I'm sorry, are you talking to me, Judge?
Yes, go ahead.
To me, I received word today that Jada Escamilla vacated the apartment, is no longer there. She called Miss Wiley's daughter. So I tried calling Miss Escamilla to confirm. It went to voicemail. I left a voicemail message. My next step is to ask the police to make a visit to see if they can ascertain whether she has vacated the apartment or not. And she was an out-of-state resident. When she got here, her residency was either in Kansas.
How long was she residing in the apartment?
About 2 months, according to her. And because she's not on the lease.
The only way she's going to be removed, because a tenancy has obviously in some way been established. She has some interest in that property, maybe de minimis, but she has some interest in that property. So that's not going to happen. And I don't know whether or not she's still there or not. I have no way of knowing.
Right. I just reported that it was said to me that she was, but I have taken steps to try to get proof. So my next step is to ask Pittsfield Police to go by and try to do a check. But being that she was never on the lease, then McKinley Properties can't even verify it because she was a guest. That was the intent, was to be a guest there. So she had a license to be there, not a lease or even a sublease.
Well, I don't know about all of that. And I don't think the court should necessarily be involved in that. I'm going to deny at this time both requests. Maybe if you find out something later, Judge Washington will entertain it, but I'm not going to change anything. Motion for any modification of bond is denied. Can you compare me? That says that. All right. Thank you. So bond will continue.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in first. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it, ma'am?
Okay.
I have no patience for that. The truth, at the end of the day, I'm sitting up here, I'm the one that needs a drink.